Good morning, everyone. Thank you so much for joining us today for this, what we believe is an important and vital topic, not only in the legal profession, but in the wider workplace and in education admissions. I'm David Sarnoff. I'm the founder of Sarnoff Group. I'm a former attorney, was a litigator for several years, was in executive search for many years, coaching and consulting attorneys and law firms and legal departments. And for the past several years, I've been a certified executive coach and workshop facilitator and actively involved in diversity, equity, and inclusion programming. I'm grateful to be joined today by my co-moderator and DEI committee co-chair, Brittany McDonald, the Honorable Zachary Carter, and Taurus Mullins. We're looking forward to having a lively and engaging dialogue today on our panel, Overruling Grutter, What Does Ending Affirmative Action Mean for Voluntary DEI Workplace? And we're gonna have each panelist introduce themselves, start with co-moderator and co-chair Brittany McDonald. Welcome, Brittany.
Thanks, David, and good morning, everyone. So my name is Brittany McDonald. I am David's other half, as you just mentioned, on the DEI committee of the New York City Bar, currently serving as the co-chair for about another year or so. But in my work and professional capacity, I am the senior counsel for labor and employment at Diageo, covering the span of North America and also currently both the UK and Europe as well too. And largely a huge part of my remit is also working and partnering very closely with our DEI professionals within my organization, and in addition to my various HR business partners and HR directors, to partner closely alongside them in managing through various DEI goals and initiatives that the company would like to set forth or have set forth, and just continuing to monitor and measuring those different initiatives and goals. So very excited to be here today, very excited to be speaking with our panelists that we have lined up here today, and looking forward to a fantastic and an engaging dialogue.
Thank you so much, Brittany. Zachary, would you please like to introduce yourself for our audience? So Zach has a fire drill going off in his building right now, so hopefully it's going to cease soon, but we will pivot back. Taurus, would you please let everyone know about your experience?
Of course. Well, good morning, and thank you again to David and Brittany and the Bar Association for welcoming us today. So incredibly excited to be here with Zach. My name is Taurus Mullins, and I have the privilege of serving as the founder of TGM Consulting, which focuses on diversity, equity, and inclusion consulting with an emphasis on organizational change. Along with that, I also have the opportunity to serve as the senior manager overseeing global employee experience for a tech company of more than 800 employees spread across the entire world. And my team is responsible for every touch point of the employee ecosystem, particularly focused on diversity, equity, and inclusion initiatives. And I'm really excited for this conversation in particular because prior to those experiences, I actually received my graduate degree in higher education and spent 10 years working at various colleges and universities across the country, grappling with these exact conversations in the campus environment, recognizing that it had direct implications to the broader workforce. So very excited to be here with all of you today and engaging in what I hope will be a robust conversation.
Thank you so much. And Zach, can you weigh in, or do you still have background noise? So for those who don't know, Zach has had an esteemed and prestigious career. Some of the highlights, he was the U.S. Attorney in the Eastern District of New York for some of its most important and historic cases. He was a longtime partner at the law firm of Dorsey and Whitney for several years, and was also corporation counsel for the city of New York, as well as a previous United States magistrate judge. And I hope I did that justice for you, Zach. So I'd like to give you an overview of how we got here today on this panel. Brittany and I became the co-chairs of the Diversity, Equity, and Inclusion Committee last September, and want to thank our committee for their engagement and involvement. We've had high-level dialogue on topics impacting DEI in the legal profession and wider workplace. And we became concerned at what we saw as the erosion of various rights for people of color, for people of underrepresented communities. And we just saw that also impacting everyone in the workplace in not the most positive way. And we started to follow the line of cases out of Harvard and the University of North Carolina, which we'll speak more today, and the impact that it could have not only on college admissions, but diversity, equity, and inclusion efforts, not only in public workplaces, but in private workplaces. As many of you have already seen in the states of Florida and Texas, public universities have lost funding for DE&I initiatives. Director of DE&I and DE&I manager positions are being eliminated. And in many of these institutions, just uttering the phrases diversity, equity, and inclusion can impact your livelihood and your position, which we find incredibly concerning. So now we're at the point where the Supreme Court is going to be releasing their decision in the Students for Fair Admission versus Harvard University and the Students for Fair Admission versus University of North Carolina. These cases were litigated against the oldest private university in the country and the oldest public university in the country, with the end goal of overruling affirmative action and the Grutter precedent, which was affirmed as recently as 2016 in the Fisher versus University of Texas case in 2016. So let's go back a few steps and start with Taurus. Taurus, you and I have had many conversations about historic and systemic racism and discrimination, centuries of slavery, decades of Jim Crow, segregation. If you could speak to what led to affirmative action being a practice in the first place.
Yeah, great question, David. And I appreciate that for kind of setting the context that we are going to be engaging this conversation around. You know, I think first and foremost, it's recognizing the fact that systems are designed to elicit a specific outcome. And so the way that our system, particularly here in the United States, has been structured is with race as an underlying input across the board. And so if you can think about it in this vein, for systems that have been codified to ensure that certain folks maintain their rights at the cost of other folks, there's no incentive to necessarily want to see that adjust or change. And so to think that the United States is not grounded on a system that is undergirded by race, class, and gendered, we really can't even start this conversation. And so I'll give you an example. The Racial Equity Institute, which is in Washington, D.C., released a really powerful white paper a few years ago talking about the fish, the lake, and the groundwater. And they use it as an analogy to talk about systems change, particularly when we're talking about race. And so the analogy that they offer us is imagine you're walking along the shores of Lake Michigan on the beaches of Chicago, and you happen across a dead fish. You might say to yourself, anecdotally, it's just one dead fish. It's not a big deal, and let it be what it is. And then a couple days later, you're on your same walking path, and instead of seeing one dead fish, you now come across a couple dozen dead fish. So you might say to yourself, okay, well, you know, yesterday it was about that one individualized fish, but now that I'm seeing so many, maybe there's actually something wrong with the water in this lake specifically. And so it's, again, still contained to that environment, but it's about that lake and the water. And so that evening, you go home and you're catching up on the local headlines. And what you find out is rather than that being isolated completely to the Lake Michigan area ecosystem, it's actually getting reports of dead fish popping up across all 5 lakes across the broader lake system. And so in that situation, it's not about the individualized fish. It's not about the specific lake that the fish live in. It's about the groundwater. The groundwater and those aquifers is what feeds into the overall lake ecosystem, which is impacting the fish. And so when we're talking about race and systems change, we're actually talking about groundwater problems that require groundwater solutions. Affirmative action, and we'll get to this a little bit later, is really addressing that singular fish or those couple dozen fish, but it's not going to the root cause of what's actually underlying the system in the United States, which is that race is such a compelling factor that we don't want to explore. The second piece that I'll share about this, David, is the fact that talking about race is inherently uncomfortable. What are we told and taught as youth, right? That you don't discuss race, religion, and politics, because those are those third rails that you don't want to engage with. And yet those become the exact factors that drive so many systems in our country and the social stratification that we live in. I like to call it this idea of social smog. We're all breathing it in constantly, and until you take a step out of it and actually appreciate that the air is not clean, which we just went through not even 4 days ago here in New York City with the wildfires in Canada, until you can actually appreciate that the air is not clean, you can't start to address the problem of what's going on. And so if we use that analogy from last week, sure, we had wildfires that were raging in Canada, which impacted our air quality here, but the fire was just that lake water that was actually being impacted by broader ecological impacts of how global warming might be impacting our society. And so what do? As a country, and when we look at the narratives that we take in, we quickly will deflect to other conversation points, whether that's gender, how somebody has access to resources, to engage in a conversation that's a bit more palatable so that race doesn't have to be engaged with, because that's really uncomfortable. And that's not just about the higher education space. We see that showing up when we look at the composition of leaderships, of organizations, of our partnership, of our boards of directors, and what that looks like. And so that goes to that final piece, and then I'll pass it back over to Zach over the next question, is that the narratives matter. We take in so much information every single day through the media, through our mobile devices, that impacts the worldview that we make sense of. And so the narrative that's been created, very artistically, mind you, is to create this idea of somehow it's an us versus them. Or to be very frank with our audience today, folks who might identify as white or adjacent to whiteness, and folks who identify as Black, brown, or people of color. And so this us versus them tension that we're navigating against is actually a false flag on the play. The reality is this whole narrative that affirmative action, quote unquote, benefits racial minorities the most isn't accurate. The data statistically, if you go back and review admissions portfolios, which I've done through my graduate research, is affirmative action statistically actually benefits white women the most. When we look at the transformation of demographics across college and university campuses for the last 30 plus years, we have seen the greatest gains in that area, and we are still struggling to keep up pace with racial minorities or folks who might come from different socioeconomic backgrounds. And that then shows up and trickles into how we have those pipelines for our institutions of private and public offerings in the economy. And so in this moment, when we're thinking about the spin and that narrative that's actually come up, by aligning on something that can be polarizing like race, we're able to not actually engage in a conversation of who actually statistically been the best beneficiaries of it. And that is part of the backdrop of what we're dealing with, is we don't want to talk about it unless it's actually convenient for creating that dichotomy. So I'll pause there.
Thank you so much, Taurus, and Brittany, thanks for putting the message in the chat. Again, we'd love the audience to submit questions, comments, reactions, and make this engaging. Welcome back, Zach. I see you've unmuted. So please feel free to make some intro remarks, and then I'll pose a question to you.
Sure, and thank you for inviting me to participate on this this panel on a subject that has always been near and dear to me personally and professionally. I'd like to start to talk about the origins of race discrimination in America. And we have to start at its beginning point, and that's with slavery. And I know that it's not always fashionable for there to be a discussion about our remote history, because there is this illusion, or I would rather think delusion, that those remote events are no longer relevant. But the reason why affirmative action remains necessary is because it remains the case that America has a unique relationship with the people who were once its slaves. When you think about the psychology of slave ownership and what is necessary for people who would like to believe themselves to be decent, religious people to accept a system in which they are permitted to own other human beings, they have got to develop a belief system that permits them to regard the human chattel who they own and over whom they have the power of life and death as being something less than fully human. And so when you accept that there has been an unbroken continuum from slavery to sharecropping to Jim Crow to racial segregation that has been official and sanctioned by law, and racial discrimination that has been the product of stubborn patterns of residency in the United States. Affirmative action is necessary to make a valiant attempt to put that particular genie back in the bottle. That is to disrupt this stubborn belief system about the inferiority of the descendants of slaves, particularly in the area of intellect. And in my view, affirmative action can be part of the solution to our racial discrimination problem, because in my experience, diversity programs have only been enduring and successful and sustainable when diversity becomes a lived experience. So one of my favorite examples about diversity in a non-racial context is America's difficulty in accepting the leadership of women, particularly in the office of President of the United States. We did, after all, reject a former United States Senator and former Secretary of State in favor of a game show host. So it is a very difficult, hopefully surmountable problem. But then we have to ask ourselves, why do democracies in other parts of the world seem to have no problem electing women to the presidencies of their republics, right? Whether it's in Europe or other parts of the world that used to be European colonies. And what I would submit is that because we in America are, as much pride as we take in our democracy, are at one disadvantage. Because we've never been a monarchy, we've never had the most important accidental benefit of a monarchy. It sometimes produces queens. That's what I mean about diversity having to be a lived experience. European queens have been just as ruthless and tough in times of war and difficult diplomacy. And even countries that are offshoots of the European experience, whether because they were former colonies, as in Pakistan and India, or have, because of just the progress of history, with the founding of Israel, a state that is in a perpetual state of siege, have had no problem electing female leadership, even in times of war and great diplomatic tension. And so in my experience, when whether it's in an academic institution or in the workplace, people are subjected to diversity. When they have a colleague who is African American, when they realize that notwithstanding perhaps an unconventional speech pattern, perhaps a Southern accent, perhaps heavily accented English, that, he turns out to be pretty smart. He makes consistently prudent decisions. He is a person, or she's a person, who I actually enjoy working with. That has to be part of a lived experience. And that's the reason why, in my view, affirmative action continues to be important.
And Zach, can you just give us a brief definition of affirmative action and how it's practiced?
Well, I think it takes a lot of different forms. For me, affirmative action at its best is an initiative that employs the use of alternative measures of excellence. Doesn't sacrifice merit. Indeed, it very often, if it's done correctly, is more meritorious or more merits-based than the stubborn adherence to the same old criteria that produce the same results from generation to generation. I consider myself a proud product of affirmative action. I graduated from NYU Law School in 1975. And during that period, as is the case now, U.S. attorneys' offices, particularly in the larger districts in the country, as exemplified by the Eastern and Southern districts of New York, never hire assistant U.S. attorneys directly from law school. But fortunately, there was a U.S. attorney at the time of my graduation from law school, David Traeger, who ultimately became a federal district court judge and was also during his career dean of Brooklyn Law School. At the time that I was considering jobs after law school, David Traeger, criminal division in the U.S. Attorney's Office had no African-American attorneys. Now, the policy of his office and all U.S. attorneys' offices was that you had to have 3 years of prestigious law firm experience or a federal clerkship in order to qualify for an appointment as an assistant U.S. attorney. And I had neither. But what I did have was this. I had been a student intern for the Juvenile Rights Division of Legal Aid. And under the Student Practice Act, I was able to try juvenile delinquency cases in the family court under the supervision of an admitted attorney. In addition, I was enrolled in the NYU Criminal Law Clinic. And back in the days when, as a matter of policy, local DA's offices permitted preliminary hearings in lieu of grand jury presentation, I was able to conduct preliminary hearings in Manhattan Criminal Court, which involved the cross-examination of dozens of police officers in preliminary hearings, which meant that I actually had more hands-on courtroom experience in examining witnesses than the attorneys that the U.S. Attorney's Office had been hiring pursuant to its age-old policy. So he gave me an opportunity to be appointed. And so I started as an assistant U.S. attorney out of law school in the December of 1975 at the age of 25 years old. And after spending 5 years there, I left there as the deputy chief of the criminal division before I was 30. And so things seemed to have worked out okay. Again, because he employed alternative measures of excellence. It didn't have to sacrifice quality. My performance proved that. He just had to think, what is really required for a functioning assistant U.S. attorney at the highest level.
Thank you so much, Zach. And Taurus, if I could bring you back into it. So after listening, to Zach and talk about that history of racism and discrimination and how affirmative action has created opportunity, are there forms of bias and discrimination that continue to remain? And I believe there are, and I'd like you to talk to them. Is affirmative action the answer, or is it one of several answers?
Yeah, it's a great question, David. And, I really appreciate Zach's reflective insights looking at the 400-year trajectory of the United States and that juxtaposition of we've never had a monarch who might have been a woman to help to inculcate our culture of understanding the power of female leadership. When you think about the more than 400 years that the U.S. has grappled with this strange fruit that is race in our country, we're trying to unravel something in less than 50 years that's had more than 400 years of precedent before that, right? So that's deeply ingrained in our DNA, is to look through the lens of that, going back to that smog analogy. And so, as I shared, affirmative action is just one approach to potentially addressing this in the education sector, and that does have implications for employment. But you see racial discrimination still showing up with employment practices, with opportunity to fair housing. We just saw the Supreme Court release a decision last week regarding the redistricting in Alabama and how we have seen pervasive moments across our country where access to equal voting rights is being directly impacted and eviscerated for populations defined by race. We're seeing conversations about critical race theory, the defunding of particular offices and initiatives using public tax monies that all people pay into are now being removed. And so this continues to be a hydra that's just morphing. We're going from, okay, it's no longer going to be inculcated segregation that's state sanctioned to de facto segregation, to now we're seeing it in a much more nefarious and creative mechanism, but it's still actually happening across the country to help to maintain that quote unquote status quo that benefits certain populations over others. And affirmative action, by definition, in terms of how the court made sense of it, was the government's compelling interest in affirmatively being involved and helping to create greater equity and access for folks who had historically been disenfranchised based in our country. And so let's use fair housing as an example, right? We know that historically certain folks had access to live in certain neighborhoods. That was by design in terms of redlining and how they were actually able to gain entry into those certain spaces. And so as a result of that, it created this complete dichotomy in our country where those experiences were really normalized across the board. And now, as we're seeking to diminish that, we're rubbing into some very real tension that comes along with that. And what I appreciate that Zach offered is that it doesn't have anything to do with meritocracy, because that often becomes another point that folks will raise is that, well, the person earn their access to be there. Well, I would argue that the folks who are able to enjoy the benefits of generational wealth and all the privilege and access that comes with, did they necessarily earn that, quote unquote, or was that one of the wonderful virtues of having a family that was able to accumulate that over years in comparison to populations who were unable to do that? And so affirmative action in this moment, it's a Band-Aid to a very real systemic issue. And, one of the pieces that we tussled with, particularly when I was working in higher education, and we still see that happening now, is that affirmative action means that we're somehow providing somebody access who's quote unquote less qualified. We're diluting the standard of which we expect somebody to be allowed to gain entry to the work that Zach was doing, to an employment opportunity, because we need to check a box or hit some sort of imaginary number that actually exists. And then that's, again, statistically untrue. The reality is that it actually demonstrates that candidates who might be admitted using affirmative action are actually just as qualified, if not more qualified, as you saw from Zach's example, than their peers in that situation. And a both and mentality, they also bring a different lived experience and perspective that enriches the learning or the performance of that team. And so, when I was working in higher education, one of the most compelling insights that I learned from a faculty who studied sociology was that somebody's zip code has the biggest impact on their life trajectory. Your zip code defines the schools you have access to, the resources that you have in terms of food deserts compared to healthy, safe food that you can eat, your drinking water, your tax base. Your zip code becomes the defining factor. And so when we think about that from a systems perspective and how that can cascade into who is able to then gain access to top tier institutions of higher learning, which then opens doors to internships and networks and things of that nature, we start to create that dichotomy from the very beginning, and it just gets exacerbated as people move through their life. And so affirmative action is one way that the government is trying to create some level of equity amongst the playing field where your zip code does not have to be the defining factor. We don't have a particular archetype of who's going to be successful in this role. And we're able to say, you know what, we can reimagine this because their insights, their perspective is actually going to enrich the learning of a performance rather than diminish that at the end. And looking back historically, it helps to chip away a little bit at that 400+ year history where there was no concern for that whatsoever.
Thank you so much, Taurus. And Zach, if we could go back to you with respect to the court, and I want to tie in a question that came into the chat, talking about the line of cases that have defined and implemented affirmative action leading up to the cases that we're at today. And the question that came into the chat is if we can address the Asian American experience about affirmative action. And the Harvard case was specifically about discrimination against Asians. We'll note that the trial court bench trial found that Harvard acted appropriately and there wasn't discrimination. In fact, they recently released their application enrollment numbers where 30% of a recent class was Asian Americans, and they make up 7% of the population, whereas in North Carolina, the population of North Carolina is approximately 30% African American, and they made up about 8% of the enrollment at the University of North Carolina. So can you please just give us an overview of the line of cases and what's on the line, you know, in the decision that may come out while we're speaking?
Sure, and it is an unfortunate complicating factor when we address the litigation at Harvard that Asian students have litigated their concern that they may have been, or that some may have been adversely impacted by a recruitment initiative that attempted to define diversity in the broadest possible way. And part of the problem with the conversation, if we are honest, and we should be honest because we will not find a solution if we are dishonest in our discussion about it. Anytime there is a limited number of people who can be either hired or in an employment context or admitted in a undergraduate school or law school or graduate school class, there is an element of zero-sum game that is implicated. That's just their arithmetic reality. And the way that the courts, at least so far, have split that particular hair is to say that excluding someone on the basis of their race is clearly prohibited under the Constitution. But to have a policy whose goal is to increase diversity and to take race into account as one among many factors that helps you to arrive at what is at least currently regarded as a laudable goal in both higher education and in the employment context, and that is having broader diversity and inclusion, that the fact that in this zero-sum game, not everyone is going to be admitted, and that if you admit person A, it may be that mean that there won't be room in the class for person B. That is not so far prohibited under the Constitution of the United States. So long as you do not use race to exclude, you can use race to include in furtherance of achieving diversity. But we'll see what this court decides. I mean, God forbid the court should decide, and I doubt this, but anything's possible, that diversity and inclusion is no longer a laudable, legitimate goal. It wouldn't surprise me that if at least one member of the court were to hold that view. You can guess who that is.
Well, thank you, Zay. And one thing that you talk about, this zero-sum game, this notion of scarcity. Taurus and I have the privilege of working with a DEI expert named Joy Stevens in our work with Loeb leadership. And Joy talks about, this notion of a pie, that if I get a piece of pie, there's less pie for you. And she discusses to view it not as not having a piece of pie, but look at it as fire. And if you have fire and you share fire with me, we could spread fire. I mean, the research out of the Great Place to Work and McKinsey has constantly shown that the most diverse teams tend to be the most innovative, productive, high performing than homogeneous teams. And before I pass it over to Brittany to take us through the rest of the panel, Taurus, would you like to weigh in on the Asian American component of these line of cases in the diversity, equity, and inclusion space?
Definitely would love to. I think that one of the pieces to keep in mind, particularly when we're talking about the plaintiffs in this situation, is this is also another moment where we're tethering historical sociological phenomenon to this situation as it pertains to race-based admissions. And what I'm talking about is this notion, first and foremost, of the Asian American community as a monolith. That is completely not remotely the situation, because we know that there is immense diversity and unique experiences within the community across the board. But when we look back historically, and you can go all the way back to World War II and then the years that followed that, what we've seen constructed in the United States is two things. One, it's this notion of the model minority myth of Asian American individuals in the country, again, speaking in broad generalities, have been positioned as they're the ideal minority that we would like to see all other underrepresented groups emulate in many ways. And this becomes a double-edged sword in terms of it reinforces this mindset of an us versus them. And that distancing and that othering allows for there to be more segmentation within the communities of folks of color and the solidarity that might exist there. The second piece along with this is underlying that in many ways is anti-Blackness and how that shows up in racism. And so going back to what I shared at the beginning, it's about proximity and adjacent nature to what somebody might perceive as whiteness or white ideals in our country, and being able to push against that. And so in this moment, having the race-based complaint really be grounded through somebody who's also a person of color completely shifts the way that it's perceived, because it's about, oh, well, this minority group feels like they were discriminated against because other minority groups actually saw a benefit. And that's, again, a false flag on the play. And so I think it's really important to just be mindful of that this is also continuing to reinforce a wedge within the communities of color in the United States that is grounded in race, but particularly making sure that there is distance between folks of color in the US.
Well, let me just add one thing. And one of the reasons why I thought it was important to bring the discussion back to its remote historical roots is that the aspirations of African American descendants of slaves, in my view, with the development, the morphing of DEI into being something that was not focused primarily on making things right for the descendants of slaves, but spreading out these benefits to large numbers of other disenfranchised people, is that the aspirations of African Americans, in my view, have been smothered in the weak gravy of colorism. How often have you confronted a predominantly white employer and asked, well, how many African Americans have you hired? And their response is not to respond directly to that question. Oh, well, we've hired 20 people of color. And you have to say, I didn't ask you that. I asked you how many African American, oh, well, one or maybe none, right? Because again, because of a long and stubborn history of regarding African Americans, the descendants of slaves, as being less than. Whenever employers and historically even schools have had the option of being able to fulfill their mission and diversity by hiring people of or admitting people of color other than the descendants of slaves, unfortunately, there are some who resort to that more readily than others.
Great. Thank you. Thanks, Zach. Thanks, Tara. So I've actually just been sitting here just sort of soaking in sort of the first half of this conversation, which I thought and I think has been incredibly engaging and just thoughtful, and appreciate, most importantly, sort of getting us into that uncomfortable territory so that we can have real and thoughtful and transparent conversation. But moving us to the second half of this portion, the other part of this, which is affirmative action and its potential impact in the private workplace, considering what we might hear from the pending Supreme Court case. And so just to sort of take us a step back, right? And I know that we've been painting the historical landscape and I love it, but if we can just maybe shift just a few years ago in 2020, in the wake of the George Floyd murder, in the wake of, a lot of activity that we saw, in response to that, most poignantly, we saw a number of corporations, private workplaces, publishing very bold corporate diversity statements to show their support in response to the activity that we saw in 2020. And as a result, we saw some of the things that I heard mentioned earlier, a flurry of activity being implemented from corporations, to the appointment of chief diversity officers and other DEI professionals. And David and Tara, I think you probably could speak to this a lot. And then the engagement and re-engagement of ERGs. And even in that respect, one thing that I think I saw also personally, when we were engaging some of our ERGs, I almost saw some of our ERGs, at some point, I felt sort of burdening or sort of kind of shouldering the burden of what I felt that many corporations were now sort of kind of setting forth as its obligations. We were sort of putting forth our different ERG heads from different ethnically diverse communities to sort of kind of be our spokespeople and speak on behalf and sort of take those initiatives forward, which whether or not that's fair or not, I have my personal opinion about that, but we saw a lot of that as well too. And then we saw, amongst a majority of many other things, the publishing of, various hiring goals, most poignantly and primarily related to individuals from ethnically diverse backgrounds. So understanding everything that we're talking about in terms of the Supreme Court cases is hypothetical, and I think we all have an indication of where it could lean. If the Supreme Court, let's just take it, were to overturn Grutter and the affirmative action cases, how might this affect the DEI commitments that I just talked about in the private workplace, and what should companies start to think about? And Taurus, if you don't mind, I'll start with you.
Yeah, thanks for that, Brittany. I love to use the phrase that I'm sure many folks on the call are acquainted with. It depends, right? And the reality of the matter is that for many, many years, higher education has created the conditions that then trickle into the workplace, particularly when we think about when it comes to diversity, equity, and inclusion. And part of that is because when we look at the conditions that exist on our college and university campuses, when those matriculated students reach their employer and they don't see that replicated, they start to hold those persons accountable to then say, okay, how do we do this? So to use an example, often, similarly, in 2020, we saw a resurgence. We saw a huge surge of organizations having conversations about gender pronouns and the importance of why it matters to have somebody add that to their email signature or to their Zoom profile so that you are addressing them with the correct pronouns. higher education was having those dialogues more than a decade ago. That was known information in that space. However, the generational catch up finally happened in the workplace, and people realized I don't want to have to sacrifice parts of who I am just because of the employer that I work for. And so now, to your point, Brittany, we're seeing organizations that in this moment, this unique inflection moment in history, created these compelling calls to action, dropped their gauntlet to say, this is our commitment. We saw even the federal government making Juneteenth a federal holiday across the entire country as a way to say, okay, how do we start to move the needle? And so I would imagine that immediately this decision is not going to be some hammer drop on DEI programming commitments in the private sector and organizations that have really started to reimagine how they show up. In many ways, I can actually see, going back to the point that Zach was sharing, the opposite might happen for some private employers of having to be even more stringent in how they actually communicate and adhere to the commitments that they've already made, because now we're working against the backdrop of we see that there's not that obligation, but the employees are actually going to expect more. My first inkling, if you're kind of following the order of operations, is after we see the initial implications for the higher education space and how colleges and universities are going to respond. The next space that I would actually be keeping a keen eye on is our public sector, looking at our municipalities, any publicly funded services, and how they're going to respond, because that's a direct tether back to using public monies that we can then say, okay, well, the taxpayers don't want this, or our legislator doesn't want this, and they're using the Supreme Court as this is going to be our grounding point to actually inform that. For our private employers, I think in the next couple of months, probably 18 months or a little bit further down, we'll actually start to see what is going to be the broader implications. Along with that, I think particularly for the legal space, and David's already alluded to this about the fact that the research has shown overwhelmingly that diverse teams actually perform better, they innovate more, clients are more satisfied, and better returns on investment, is so many organizations are going to be at a very real inflection point of asking themselves, who do we want to be and how does that show up? And at a certain point, it's no longer going to be about, okay, well, we want to be avoidant of potential litigious situations. What's our workforce expecting from us, and how do we actually deliver on that at the end of the day? And I talk to clients about this all the time. About a certain point, it's going to come down to you making a firm decision, and you're not going to be able to waver anymore. You're going to have to pick a side to fall on. And so that's why I go back to that point about narratives that I was talking about at the beginning. Is because in light of this, whether we are looking for increasing the diversity, the diverse composition of our workforce, candidates who are going to these colleges, universities are going to be even more keenly aware of how that's showing up with their prospective employer. And that's really important to keep in mind, particularly when we think about the generational nuance that right now we've got, what they're reporting is 5 generations in our workplace right now. The folks who might be sitting at that decision-making table at the partnership level might look very different in terms of their composition and their worldview compared to the folks that are coming in as entry-level employees who have a very different expectation. And so just as we saw in the last 10 years, a resurgence of admissions and popularity and the influence of HBCUs and HSIs, Hispanic serving institutions, we're going to start to see that likely is going to occur again as folks flock to the schools and the organizations that are really embracing this. And we're going to start to see an even more, a bigger division between the companies and organizations that are really reflective of our changing demographics across the country compared to those which might not be.
Thank you, Taurus. And so shifting just a little bit to where you were talking about it, maybe if we can just unpack it a little bit more, just in respect to the hiring and decisions, the hiring and recruitment decisions of private workplaces, and not only within the private workplace, but just also even maybe if we can just step back a little bit and talk about the college admissions process as well too. Zach, do you mind sort of kind of touching on that a little bit, and how the potential decision, if it were to be overruled, could potentially impact those areas? And if I could just give you some of my thoughts around what I'm thinking about in terms of the hiring and the recruitment in the private workplace, most pointedly thinking about sort of, when and it was certainly before 2020, but I certainly saw an uptick post 2020 of reverse discrimination claims, for instance, and just different other discrimination claims, or you're only hiring this person or recruiting or promoting this person because of X, Y, and Z. They're from this ethnically diverse, whether it's Black, African American, Hispanic, Pacific Islander, Asian American, and so forth. So if you wouldn't mind just touching on that just a little bit.
Sure. First of all, I think that we shouldn't be focused exclusively, particularly if there's an adverse ruling in this most recent Supreme Court case on affirmative action, as opposed to going back to first principles and focusing on continuing racial discrimination. And that's not going to manifest itself the same in college admissions as it does in employment. And it's not going to manifest itself in exactly the same way in all areas of employment. There are going to be situations in which, based on the numbers alone, it should be apparent to any reasonable person that there is ample evidence of ongoing racial discrimination. So giving an example close to home, New York City had to settle a lawsuit brought against the fire department about its pathetically low single-digit representation among the ranks of firefighters among African Americans. And when you ask yourself what it takes to be a first-rate firefighter, and you think about the criteria, it requires somebody who's physically strong, because you have to carry, hundreds of pounds of equipment, and occasionally you have to carry out human beings during the course of a fire. You have to be reasonably athletic. You're climbing in and out of windows and navigating obstructions. You have to have a level of physical courage that would permit you to risk serious physical injury and possibly death. You have to be sufficiently intelligent to process sometimes complicated instructions, because one day it may be a simple house fire, but the next day it could be a Manhattan high-rise. And you've got to be a team-oriented person, because you have to coordinate your efforts with others. Have I not just described an NFL football player? Have you noticed any shortage of Black guys in the NFL? Right? So if you've only got 3% of Blacks in FDNY, you don't need to talk about affirmative action. You're talking about discrimination. And there are other areas of endeavor where you can similarly make that point. When you talk about the NFL, we finally got around to permitting NFL teams on the field to be led by African-American quarterbacks. The thinking man's position took a while before those who were the deans of that sport permitted that to happen. But what's the next step? Why are these now retired quarterbacks not in the mix to be the head coaches of those teams? All right. So I think that this is a complicated problem, which if we just look at either affirmative action or discrimination without trying to harmonize all those things and seeing how they complement each other, we won't make sufficient progress.
Yeah. And in that vein, just in the spirit, because what's troubling to me, and Tara is now maybe pointing it back to you, is the fact that just considering some of the momentum, all of the shift that we've seen in this space specifically, and it's near and dear, of course, to me from the private workplace sector, could the potential decision impact the ability of private organizations to continue to sort of kind of set these bold and these bold sort of goals and initiatives and sort of implementing their own sort of DEI strategies? Could it impact those particular sort of that particular sort of space?
Well, it's a great forecasting question, Brittany, and I would offer that in reality, it likely should not. across the board. Of course, there might be outliers, particularly if you have a very litigious space that you're working in. I know I've had the opportunity to work with clients where they will have members of their own company where they're worried about, oh, well, if we launch this employee resource group program, or if we create this position, there are folks internal to our own company who are going to throw up very real roadblocks. That already exists now. And so the reality is that as organizations react and have to morph their approach to what this looks like, they're going to be very thoughtful about how they engage in those commitments and what that reporting and communication looks like. I think one of the first big inputs that we have to keep top of mind is that the leadership matters of the organization, and really being thoughtful about who is the person who is setting that tone, how are they ensuring that they're inviting the right folks to be at the table and to be part of that conversation, and then how do they cascade that down to the broader employee workforce of that organization. What I often see, and I know that we see this a lot in law firms, is that we want to wait and see. So what's somebody else going to be doing, right? And so I think that mindset of, oh, I want to see what this firm is doing or this organization is doing before we react because they're a bigger name, will actually slow that process across the board, as some organizations might say, let's just maintain our current course, see how things shake out before we do anything that's going to be particularly revolutionary, quote unquote, if you will. Along with that, you've got to keep in mind, and that's why I say that cascade of going from institutions of higher education to publicly funded organizations to private institutions is where that money is coming from. Part of the reason why Harvard, it was one of the defendants in this Supreme Court situation, is because they are held accountable to the same money expectations and federal laws that UNC Chapel Hill is held accountable to as an institution of higher education. And so if you're a fully privately funded organization, you're going to have different flexibility that you're able to exist within. That does not mean you can go out and engage in discrimination like Zach was talking about, or violate equal employment rights laws, but it does mean that you're going to have a different level of flexibility to operate within. What I imagine many private organizations are going to do is we're going to start to see some schism between of those that are really going to double down and say, you know what, we are truly committed to this. This is part of who we are. It's in our values. And this is how we approach the work that we do, compared to organizations who, going back to Zach's point, might say, well, you know, we hire diverse candidates across the board, but we're not going to really lift the veil too much for you to see because we don't really want to wade into that water too deeply. And so these next few months, if the decision does come out and the years that might follow, I imagine that this is also part of a test by Edward Bloom, who's the person funding the majority of this, and other groups across the board. I imagine that this is also going to be a potential canary in the coal mine of seeing what is the court's appetite for arguments of this nature. I think many folks were surprised about last week's outcome with Alabama, and now we're actually seeing that we either could see the same situation happen now or something wildly different, and that might become a snowball effect to future cases that could have much more direct implications on private employers down the road.
But
Yeah.
I also think we have to be relentless in making the case that diversity is an important value, not just to formally, to traditionally disenfranchise people, either based on race or gender, but to the institutions and the companies that embrace diversity as a value in terms of improving the quality of decision making. And among the audiences that have to be impressed in a profound and personal way are the 9 justices of the US Supreme Court. I mean, when you look at the woeful statistics of the representation of women and persons of color, much less African Americans, as clerks on the US Supreme Court, you have to wonder how many of them think that diversity is an important value. Or to flip it on its head, are there some members of the court who believe that, given their membership in a particular, racial group, do they already know everything that's worth knowing? And do only people who look like them know anything that adds anything to any conversation that's germane to any decision-making on the court? Because it's when you think of, and I am I say that and it sounds pessimistic, but I'm not pessimistic because we have the example of Brown versus Board of Education. Now, Thurgood Marshall and the Legal Defense Fund did a brilliant job of, strategic planning in managing the cases that led up to Brown versus Board of Education. And they made some brilliant legal arguments. But a lot of people believe that what ultimately won over the day was Marshall presenting to that court the study, the sociological study that established that in 1954, if you gave little Black girls the choice between playing with white dolls or Black dolls, that overwhelmingly these little Black girls rejected the Black dolls and embraced the white dolls. And guess what? 9 old white guys said, that's just unacceptable. All right. So I'm optimistic that if we find the right tune to play, the right message, that we can reach even this court.
And to that vein, just ensuring that diversity is sort of is paramount, and it's still sort of front and center of the conversation, and that folks realize that it is an important concept that must be utilized and sort of embedded in sort of our workplace DNA and our DNA in other industries as well too. Taurus, I'm just also thinking about your point of that first cohort of workplaces in terms of those who might double down and say, you know what, we're going to continue the DEI, despite this is what's being said, we're going to continue forward. We've made a lot of shifts, we've made a lot of momentum, we don't want to lose that, so we're going to continue to go forward. However, I want to balance that against the fact of what may be at that point in time legally acceptable and not legally acceptable. And so just thinking about, of course, understanding all of this is forecasting, all of this is hypothetical, what are maybe some alternative strategies those corporations could think about should they be faced with, the unfortunate sort of situation of, we have to sort of kind of begin to switch course in how we implement our different DEI goals and initiatives.
And it goes back to this idea of starting with the why, right? And this notion that diversity, inclusion, equity, and belonging, it's not a nice to have, it's a business imperative. It actually benefits the overall enterprise of the organization. And it also can't be that is the moment du jour. I saw a comment come in the chat about accountability. It can't be the moment du jour. Oh, this is nice to do this right now because everyone's doing it. But when they're not, excuse me, when the microscope is not on us anymore, now we can start to diminish our efforts, right? Because that's just performative engagement, not actually deeply entrenched engagement in the organization. And I often tell partners that we'll work with that DEI work cannot be additive. It can't be sprinkled on top of the experience after the fact. It has to be deeply integrative into the experience of the overall ecosystem of the organization. And so to go back to your question, Brittany, that really starts with the leadership. That starts with ensuring that the people who are sitting at that decision-making table understand the why this matters. Maybe it's selfishly, it matters because it hits your bottom line, and we know that that matters because you want to make money. Maybe it matters because you want to vie for the best top tier talent, and that talent wants to work with diverse teams because generationally they've grown up in a much more diverse workspace or learning environment. Going back to that why is so incredibly important. There's a really great TED Talk by Melody Hobson. She is the chairwoman of Starbucks and one of the first women of color who is a CEO or a leader of a Fortune 500 company. And she offers a really interesting analogy of if you were to enter a boardroom and around the table you saw 15 chairs, and out of those 15 chairs, 13 of them were filled with people of color and or women, you might think that's strange because we've been socialized that that's not the quote unquote norm. But yet if you walk into that same boardroom and you saw 15 seats with 13 of those seats filled by white men, your brain wouldn't even think anything of it, going back to the analogy of the dolls that Zach was just offering us. And so it really does start with those folks who are in the decision-making rooms, whether it's the board level, whether it's at the C-suite level or partnership level, because they're the individuals who are going to be able to say, this is going to be our line that we're going to hold. Now I'm going to hold every layer below me accountable to actually doing that work. So that's one. I think number two is going back to what the data internally actually reflects, and being able to paint that story and say, this is where we're at. Is this truly where we want to be? Because ultimately, if you go back to Zach's example of, oh yeah, we hired 20 diverse folks in our hiring class, but let's disaggregate that data and actually talk about, of those 20 diverse folks, what did they actually look like? And if you're actually seeing that you're not moving the needle in the key demographics to be reflective of either the broader company population or the space that you work in, then there's work to be done. You know, I did this in my last organization. We actually pulled, because I oversaw all of our talent recruitment for that organization, and we actually pulled what are the statistical, based on US Census data, what's the demographic look like, and then based on that demography, how is that reflective in our workforce? And if we weren't aligned, that we understood where are our targets that we had to really focus our efforts in, not diluting the caliber and quality of candidates. As Zach mentioned, you can go find the great people out there who bring the both and experience and knowledge base, but it really is incumbent on the employer to think about that. I think the final piece that I'll share, and then I'll pause because I know there are some other questions we want to get to, is really being mindful of the fact that, again, going back to the systems thinking, if we don't think through, okay, how do we want to have a different narrative? How do we want to see a different outcome so that we're not repeating the exact same mistakes of the past and reinforcing those same patterns? We have to really think about that in terms of what is and the more localized locus of control that can be influenced. The Supreme Court's gonna make the decision, that's gonna have implications. What you do for your firm, what you do for your home organization, that's where you have immediate impact that you can actually influence that change and say, if you're not going to be about this work and really invested in it, it might end up that you're going to lose great talent. That narrative is going to get out there. The communities will talk to each other and say, this is not the space that you want to work in, no matter how much they're going to be paying you, because they're not actually going to create the right conditions to support you. So many folks focus on, well, let's just put the commitment out there, let's hire the great talent. But if you don't create the right conditions for them to be successful internally, then we're already going to be setting up a false narrative for them. And they're eventually going to move on to an organization that actually is doing that work authentically in their everyday practice.
Yeah, no, that's perfect. No, thank you for that. And Zach, I think I'll end my last and final question of this section of the panel, just with respect to just considering your long and impressive sort of track record, sort of especially within the public sector, excuse me. How could the perception of this sort of affect, other areas within the legal industry? Just thinking about, could it have an impact and a trickle down effect on how we, select our juries or sentencing or things of that nature? Could you talk maybe a little bit about that as well too?
Sure. Again, I get back to diversity having to be part of a lived experience. And sometimes it takes time before you realize that someone who comes from a different culture than you do, who communicates slightly differently than you do, maybe even uses unconventional speech patterns, reveals themselves to be smart and wise and have great judgment and are a great decision maker and a great colleague. But that requires exposure, and it takes time. And then we have to overcome so many stereotypes. I'm reminded of my first day in property class at NYU. And I have to say, I graduated from Cornell and I was part of the class that took over Willett Street Hall when firearms were introduced. And I was briefly under indictment in connection with that takeover. But fortunately, the late, great Hayward Burns represented us and got the charges dismissed, or else I wouldn't be sitting on this panel. And certainly not as a former US attorney. in any event, I was, could possibly have been a pretty casual student, but at least in the first week, I was determined to be prepared. So I'm sitting in my in property, and Dean Hawley, our professor, asked the following hypothetical question. He said, "You are approaching the corner of 6th Avenue and 8th Street in the Village, and you see a $10 bill lying on the street corner, on the sidewalk. And you're about to approach and pick up this $10 bill when somebody who's next to you moves their foot and is now standing on the $10 bill. What do you do?" And so I gingerly raised my hand and I said, well, I would tap the gentleman on the shoulder and say, "Excuse me, but you're standing on my $10 bill." Now, the term microaggression hadn't even been invented back in 1972. And I'm not going to suggest that everybody who erupted in laughter was indulging in the stereotype of the street smart young Black kid who comes up with this, clever quip in response to this serious law school question. But that's certainly the impression that I had. But the fact is, the reason why I answered the question the way I did is because I'd actually read the material. Apparently abandoned property belongs to whoever claims it. I just happened to combine a statement of Black letter law with a practical execution strategy, right? That's the kind of thing that affirmative action and force-feeding diversity in the workplace and in academia exposes people in the complicated ways in which they're both similar to us and different from us. And that makes them as qualified as all the rest of us in ways that are not always predictable and readily apparent. And that's why this is such a difficult enterprise, and why we cannot permit those who keep moving who want to artificially, not move the goalposts and extend the time, but artificially cut off the time when these things are appropriately taken into account, as if racism is something that can be switched off and on, like a light switch. There are times when, living in America, I feel like I'm in the front seat of a car with white America in the back seat, like a couple of kids on a long car trip saying, "Are we there yet?" We're not there yet.
Well, thanks for sharing that, Zach, and I'll just jump in for a moment because, before earlier you referenced discrimination hiring of New York City firefighters and NFL coaches and quarterbacks, but given our audience, given the esteemed City Bar Association of New York, I think it's important, and you talked about being direct and real earlier, that we talk about the legal profession for a moment. And just yesterday, timely in the New York Times, the Honorable Shira Scheindlin published an essay, and it's titled, "If the Supreme Court Abolishes Affirmative Action, Here's What Women Need to Do." And she talks about how in the legal profession, Black lawyers make up only 2.2% of law firm partners, according to a 2021 NOW report, National Association of Law Placement, with Black and Latino women at less than 1%. And part of what Brittany and I and our committee has tried to accomplish over the past year and build on the success of our prior co-chairs is converting the learning to action. And this is where I think allyship is incredibly important, particularly in the legal profession, where white men and women, I think, need to advocate, need to step into uncomfortable situations, as Taurus describes, put themselves out there, intervene when there's instances of discrimination or bias in the workplace, and not just be bystanders, particularly if the court goes as far as we fear it may. I once interviewed a woman of color, Lori Boozer, who said, David, I don't need allies, I need soldiers. I don't need someone to come up to my cubicle after an event and pat me on the shoulder and say, oh, I feel terrible that happened. She said, I have a therapist for that. I need somebody who's going to step up and address it in the moment, or address it when I'm not in the room and somebody makes a bias or discriminatory statement or action. So what I'd like to pose to Taurus and Zach is, what specific actions can be taken from here going forward? Let's assume at a minimum, affirmative action is going to be greatly watered down and likely abolished. What can the private sector, what can the public sector, and there was a question in the chat about the impact on federal contractors who currently have to comply with the law. Where do you see them being impacted with respect to compliance? Taurus, would you like to?
Sure. I think first and foremost in this situation, I reflect on the quote by Eli Wiesel, of this idea that neutrality benefits the oppressor, not the victim, right? And so in this moment, there can't be neutrality around how the firm or the private organization is showing up in this moment. It needs to be very clearly articulated. This is where we stand. These are our commitments, how it aligns to our values, to the culture that we are building, and to the employees that we want to support. And that's really important for a couple of reasons. One, it sends a very compelling message to the current team that you are leading in your organization of, this is the type of employer that we are working for. This is the kind of resolute organization that is not going to waver in its commitments to these just because it might be facing some level of headwinds in the process. It also shares a very important narrative with folks who might be considering the organization as a prospective employer. Is ambiguity in these moments or tacit in adherence is not going to be sufficient, because for the organizations that are much more clear in their commitments, that's where you're going to be targeting your energy across the board. And I know this from recruitment and many conversations with hundreds, if not thousands of candidates over the course of my career who give me insight as to why they selected this organization over that organization. And those publicly stated commitments that are backed up by actions by the organization is critically important. So that's part of what I think is a first strategic focus, that you bring the right people in the room, figure out what that commitment is going to be, articulated, and share that, and be ready to stand up in that. The second piece is part of the challenge that's going to likely happen as a result if Grutter is overturned, is institutions of higher education are going to have to now grapple with, okay, so what do we do now? How do we control that narrative for our students, for our future folks who are going to be admitted? And so what I often will tell folks is, one of the ways that I've always found success in being able to build relationships and the pipelines for diverse candidates is going to those spaces, building partnerships with those institutions of higher education that we know are going to have diverse candidates, figuring out what are those programs that can be continued to support, whether it's internships, pipeline building, because that also sends a very important message that we're entering your space. We are coming to you and demonstrating to you that you have a place and a seat at this table, and we want you to be here. And we're going to work diligently to create the right conditions to ensure that when you do join us, that you're going to be successful. And so by leveraging both of those, you're able to start to think through, okay, how do we create an environment that, regardless of what the court decides, we know that we're not going to dilute our commitments to inclusion and to equitable access to opportunity for different populations, regardless of what might be the broader decision. The last piece, and this goes back to that idea of often we'll wait to see, well, what's this other firm doing? Or what is this leader in the industry doing? What's their position? Because we don't want to act until they act. Somebody has to be the torchbearer. Somebody has to be that first person to say, you know what, we're going to go ahead and lead the way. And it might be a little lonely at first, but the reality is often, it's kind of like when you're waiting for a question during a conversation. The minute that somebody does it, everyone is like, oh, finally, okay, now we can do it. Because there's when you have a critical mass of solidarity, there's actually power in doing that. And so bringing together like-minded folks to build that nucleus and that consensus is also a really powerful way to ensure that there is going to be greater protection in numbers, should there be some sort of contrary approach that comes out of that.
Thank you so much, Tarzan. And before I get to Zach, I'll just add, again, in the work that you and I do, and while I don't like to generalize, but the research and the evidence shows that there's generational components here as well. Yeah. And Gen Z and young millennials, they read DEI statements and mission statements on organizations' websites and in their materials. And if they find that you are not meeting those obligations, or at least living up to who you hold yourself out to, word travels fast, they leave or they move on from the application process.
Quickly.
Zach, some action items for our audience, where we go from here?
Sure. I mean, to put it most simply, I mean, we have to live up to our conviction that these kids who have of color who have suffered, disadvantages of low expectations, of outright discrimination, of economic disadvantage, are as talented as is necessary to succeed, and that there are holes that we can work to plug in their experience base that will have their stories turn out differently. So some of it's just about money. We have to expand opportunities for high school kids looking at undergraduate school, and undergraduates who are looking at law school or grad school to have test prep opportunities, because we know that these examinations, even the sponsors of these examinations, don't pretend that they test some innate ability, as opposed to testing for the level of preparedness as some of these kids have an opportunity to achieve when they go through intensive test prep. We also have to intervene with these kids at a much earlier stage of their lives. Long before I became corporation counsel, the law department had adopted one of the New York City specialized high schools, Brooklyn Latin, which happens to be the most diverse of all the specialized high schools, and coached them in a intra-school moot court competition. And if you ever saw these kids in action, and this audience is comprised, I think, mostly of lawyers, there's no doubt in my mind that you would think that they were either law students or admitted attorneys by the time that they finally had been trained in dealing with these moot court trial problems. So they clearly have the ability to succeed, but they need guidance from people who, like us, who've been to the end of the rainbow. And sometimes the coaching has to be in small things that people who have lived with advantage take for granted. So for instance, when I was in law school, I didn't join a study group, right? There was a piece of me that thought it was tantamount to cheating. I mean, shouldn't I be able to get this all on my own? Rugged individualism. Neither of my parents were college graduates, much less lawyers. I mean, if you grew up in a family of lawyers, they would tell you crazy. Of course, you need to join a study group. The legal profession is inherently collaborative. No one can come up with all of the brilliant right answers on their own. You need help in with colleagues who have studied the same material to come up to establish that there may be a different way of looking at a set of facts or legal principles. So we need to make ourselves available to kids, to give them a head start, to coach them around the intangibles that help to support success.
Thank you so much, Zach. And Brittany, would you like to weigh in?
Yeah, no, just conscious of just sort of where we are and just sort of kind of feeding in at everything that both Taurus and I think Zach have brilliantly stated so far. I think it's probably as simple as just ensuring that the conversation continues, making sure that folks are at a minimum aware of what's potentially before us and what could potentially sort of impact their respective sort of legal, either in the private workplace and in the higher education or the public sector, whatever it may be, ensuring that folks are aware. And I say that because of the fact that I'm internally now having discussions with some of my colleagues who have no idea that this is something that might be looming potentially before us. Of course, they see the headliners that we unfortunately all see when we, pop on our news and we see the attacks here and there. But I don't think folks know how deep and ingrained that this potential issue could be. So I think at a minimum, having the conversation, having the dialogue, ensuring that folks are aware, and then ensuring that folks continue, for those, just thinking about Taurus's earlier point and even Zach's earlier point, ensuring that diversity is first and foremost, that it is paramount, that it is still embedded within our corporation's DNA and wherever you may work, ensuring that we continue to push. So we have to, even if we have to be creative and think outside the box on exactly sort of what those alternative strategies to what we're now currently doing may be, let's have the conversation, let's start thinking about it, let's start strategizing, because I even think about the Roe versus Wade, issue. We all knew it was looming. We all, at the end of the day, it was leaked. So we had, pretty much it was right there in our face. And then the folks came scrambling and couldn't believe when the actual decision came out. So let's not repeat history and let's not do the same here. So I think, again, just at the very end, let's continue to ensure that we're holding ourselves accountable within the space.
Thank you, Brittany. And in the spirit of continuing that conversation, our Diversity, Equity, Inclusion Committee of the Bar supports the Office of Diversity, Equity, Inclusion, and Belonging, headed up by Tanya, with Angie and Mary Ellen. And I just want to let you know that they're going to be sponsoring a series of panels throughout the summer and the fall. Learn from legal experts, engage in a hackathon, and make meaningful commitments towards creating equitable access to the legal profession. Please don't miss out on this opportunity as they engage in a sustained initiative towards diversity, equity, inclusion, and belonging in the legal profession. And you'll be receiving an email post this program updating you on the calendar of events. Just 2 minutes left. Taurus, please take 45 seconds. Give us your key takeaways and overview, and then we'll let Zach close us out.
Yeah, I think first and foremost, thank you again for everyone who joined us today. And just echoing what Brittany said, silence equals the death in this, it equals death in this moment, right? And so if we don't have the conversation, if we don't raise this and really think thoughtfully about the implications of how this is going to impact not just the pipeline of well-qualified, amazing students in our higher education system, but the implications for us in our private and public sector spaces, we're already going to be behind the 8 ball. And contrarians to this are expecting that there will be continued chaos in terms of people not knowing how to respond and react and what to do. This is a time to either organize internally, organize collectively, and use that as a driving factor to make sure that we're not diluting these efforts and we're not changing the momentum that we've built, because that's going to have direct implications on the generations that are going to follow, who we owe it to do better than what we had 50 years ago. So I'll leave us there.
Thank you so much. Zach, closing thoughts?
Sure. I think that we just have to keep our eye on the ball in terms of the value of diversity, both in education and in the workplace, in terms of how it adds substantive value to the quality of our professional lives and the quality of academic pursuits. constantly reminding each other that exposing ourselves to alternative points of view, to alternative life experiences invariably enriches our lives.
Thank you so much, the Honorable Zachary Carter, Taurus Mullins. Grateful to be with Brittany McDonald, to the DEI committee, to everybody at the Bar Association who supported us in making this event happen, to the Office of Diversity, Equity, Inclusion, and Belonging, Tanya, Marielle, and Angie, thank you so much for your support, and we look forward to engaging with your programming through the rest of the year. And to our audience, thank you so much. Please feel free to reach out with questions, connect with us on LinkedIn, and let's see what the decision says.